Hi, I'm Eva from Homeowners Resource Group, and I'm here with Dominic Caligari from his own law firm, Caligari Law PC. He specializes in foreclosure defense, real estate, and other real estate and legal matters. And did I miss anything else?
No, no, that's pretty much it. I mean, I have a general real estate practice. Majority of what I do is in foreclosure. I would say about 70% of foreclosure defense cases, but it's a larger umbrella than that: quiet title, breach of contract, landlord tenant, fraud, etc. So it's a very large umbrella of real estate.
How did you get started in it? And what did you, when you first got out of law school, what were you practicing? And then how did you end up where you are now?
Well, while I was in law school, I was sort of obsessed with politics. I was very much into politics. I worked for senators while I was in law school. I worked for lobby consulting firms while I was in law school. But I had somewhat of a real estate background because my father owned real estate. When he passed, our family inherited the entire estate. So when I first met his attorney, who's now deceased, unfortunately, very great attorney. His name is David Ahern. When I met him, I realized I wanted to be an attorney. He had this, just the fact that he could control the whole room, which is his knowledge, and he was helping people. I kind of that really was what wanted me to become an attorney
Hmm.
and eventually go to law school. But I was obsessed with politics. I studied constitutional law with a minor in real estate. Because my family had the background in real estate, I wanted to kind of keep that in my back pocket. When I got my first job out of law school, I was working in a political consulting firm.
Mm.
Kind of saw what you had to do to make it to the top. Wasn't a fan of it. Realized how corrupt the system actually was. Applied for a job as a legal assistant for a developer in Queens, and then the rest was history. So
Yes. And we know some of the history of that. But so that's kind of how you learned about foreclosure defense and where
correct.
we are today and the ins and outs. You were on kind of both sides of things, knowing what would take for the bank to win versus what it would take for a homeowner to win, correct?
So somewhat, yeah. So my first job as a legal assistant was to review the foreclosure process. I didn't know what I was doing. I had someone that sort of knew what they were doing, kind of teach me, and I would just get a case. And this is in 2016, and some of these cases I was reviewing was from 2009.
Mm-hmm.
So it would be thousands of pages. Didn't really know what I was looking at. Eventually, just doing enough of them, you pick up patterns and you realize what works, what doesn't, what to look for, what not to look for. But that was 2015, I believe. No, 2016. I'm sorry. And then just reviewing all these cases, it's repetition, and
Right.
I like the whole process. So eventually, I went off my own. But yeah,
Right. And now, so how we started working together was I help a lot of people that are in foreclosure. I noticed that your name was listed as the defendant's attorney on a majority of cases I was contacting. And so I reached out to you and I said, hey, your client has this house in foreclosure. It's vacant. They're going to lose it to the bank. Let me help you with working out a short sale with the bank. We were able to either get the seller some money, get all their debt paid off, whatever the case was. And now I think we've closed a few dozen. I don't even know at this point, and we have a few dozen more to go. But so far you've been very instrumental in helping us with getting prices and the banks to cooperate in a lot of situations where the banks were either MIA or they just weren't answering or they don't even know what's going on half the time because the bank is always hiring some new per diem attorney to show up at the court cases or the court conferences for them that are just getting caught up on the case that day and have absolutely no idea what's going on. And it's like, it's like the blind leading the blind sometimes where it's like the court doesn't know what's going on, the bank side doesn't know, and then the case will just sit there in limbo for years and years. And because you know how to look through these cases, you can figure out they missed this, they didn't do that, they did right, so on and so forth. You can kind of pick apart the cases and figure out what they miss so that you can kind of help the defendant win on their side, correct?
yeah, for the most part. Typically, the best thing a homeowner can do is hire an attorney that knows how to work through the process. It is very simple. I mean, if you put up a good defense against the bank and grab their attention, they're going to want to come back to the table and say, all right, look, what does your client want to do? And they'll offer some sort of a settlement.
Mm-hmm.
But you have to put up a strong defense. Doesn't always work. Sometimes they just don't care.
Right.
And it is what it is, and that's a part of the process. But without a defense, you're essentially hopeless.
And what happens in the case where like the seller hires an attorney that doesn't know what they're doing? And
problem, yeah.
yeah,
I mean, that happens often. I mean, I've taken over, I don't know, more than, I don't know how many,
a
at
lot.
least a dozen cases where the attorney's not a real estate attorney. He's
Right.
a divorce attorney. He does, PI, whatever the case may be. And you could tell right away. You look at what they filed, you could tell almost instantaneously they're not in this realm.
Right.
And you have to come in, you substitute them out, you come in and you kind of almost have to realign the case because they're going this way and you kind of have to get them back going this way.
Mm-hmm.
But yeah, I mean, that happens often and it puts the homeowner in a very bad position.
Right.
Because their first response, a lot of the time they leave out in very important defenses. Or they'll miss
Right.
very obvious things to myself, which is not obvious to a real estate lawyer.
Mm-hmm.
Um,
So if you picked up a case where like another attorney, say, there's all stages of the foreclosure, and early in the beginning, that attorney missed a very like important factor of what could have helped the homeowner to kind of like gain a little bit of leverage in the case, how can you then go back and try to like recover what, was missed or restart it?
well, I mean, that's sort of a broad question,
Yeah.
but I mean, it's assuming they filed an actual response. The biggest problem is if they file a response, and I think I said this before, they don't put in very important defenses. When you file an answer, you learn this in law school. You throw every affirmative defense in your first response, even if it doesn't apply. It gets dismissed later on, but you have to preserve all your defenses. Anything you don't raise in your answer is considered legally waived.
Mm-hmm.
That's an issue you see a lot of the time. Um, that situation has happened, and you're put in a bad spot as the incoming attorney. And you
Mhm.
kind of almost have to assume that their answer is so broad and the court will interpret it that broad that they'll accept that defense that was actually not raised. Sometimes you raise it anyway and the court will address it.
Yeah.
New York has passed laws recently, specifically with standing and foreclosure, where if you file an answer and you don't raise standing, if you're not raising standing, you shouldn't be doing these type of cases. Like that's one, legal 101. If you don't raise standing, the court says that's fine. We'll still consider it because it happens often, and I think the New York State legislature realized that. That's why they passed that law. Now, if that's if they actually file a response. If they hire an attorney, and you see this a lot, well, they'll just go in and they'll submit a loan modification on behalf of the
Mhm.
homeowner, but they're not actually defending the foreclosure. So they're doing nothing to prevent the foreclosure or actually defend the homeowner.
Right.
They think they are, or maybe they don't realize that by submitting a modification doesn't mean you're defending the foreclosure. You're just saying, hey, bank, we're trying to get a resolution here. There's a difference. And when they do that, the homeowner's in default. Now we have to go in and file a motion with the court and explain to the court what happened. You have to provide an excuse. Hey, judge, we had a prior counsel. We thought our rights were being representative. This is just very general,
Mhm.
but you have to explain to the court. You have to give them a reason, and they have to agree to it. If the court says, you know what, you're right, we're going to vacate your default, you can now resubmit your response.
Mhm.
It happens a lot.
And does that tie into like the statute of limitations law that's been passed now?
Well, I mean, it depends. I mean, in what sense?
So if there's the new statute of limitation law, and you can correct me, is that if the bank doesn't file a lis pendens on a property from the time that the mortgage has either been stopped being paid or went into default and a certain amount of time passes, then they kind of lose their rights to foreclose.
Correct. Well, okay, so if that's a defense that you have to put in your answer.
Mhm.
If you don't, you waive it. That's a big problem because the new law is very friendly towards the homeowners.
Right.
The statute of limitations law. It's caused a massive problem with the banks. And essentially the banks are holding a lot of unenforceable debt. And their only remedy is to go after them personally. Majority of them end up filing bankruptcy, which wipes out that personal guarantee. And then they have to go after the only remedy at that point is the mortgage,
Mhm.
which has been wiped out by the statute of limitations.
Right.
I can get into a little bit more than what we just did, but if you don't raise that and there's a clear statute of limitations issue,
Right.
that is devastating to the homeowner.
And then if it goes to the next phase of the foreclosure and that wasn't brought up, then it's kind of like you
Waived.
can't go backwards. And
Waived, yeah.
right.
Yeah.
So that could be a big detriment to hiring an attorney that may not have picked up on that in the beginning or something. You could actually lose your chance to win the case because you didn't hire the right person.
Correct. You want to try to get that case, at that point, you want to try to get it dismissed for some other reason.
Mm-hmm.
and then they start a new case. Now you can re-raise the issue.
Right. Does any of this have anything to do with the Homeowners Bill of Rights in New York?
Well, the Homeowners Bill of Rights is, so in 2016, the legislature passed the rule that when you go into settlement conferences, so in a foreclosure, they file a lawsuit, which is they file their summons and complaint. The next stage is they're going to go into settlement conferences, assuming you're entitled to them. They now made it a law that when you go to that conference, the court or the referee has to hand you a document called a Consumer Bill of Rights. And essentially it just says you have a right to an attorney, you don't have to leave your home,
Right.
with a bunch of other laundry list items that homeowners previously didn't know they had those type of rights. And now they have to provide that. Now, that doesn't actually have anything to do with the statute of limitations per se, but that law in particular is now required to be at settlement conferences.
And it's one of those things that if the bank misses this checklist of giving homeowners certain notices and things like that, then it could also prevent the case from having moved forward.
It potentially can. There are, that issue is something I remember I did raise several years ago. We never had it decided by the higher courts. But I'm sure it will be an issue that some attorney is going to raise. It might be already before the appellate division.
Right.
It's the higher court. I don't know yet. I didn't see that it was, but it might be. But that is probably an issue that will be litigated. If you don't provide them the Bill of Rights, now what? Do you restart the settlement conferences? I don't know.
So what's the difference between somebody being in foreclosure or being foreclosed on versus a foreclosure? Because everybody kind of like mixes those terms up like all the time. People are like, oh, that house is in foreclosure, the bank owns it. And I'm like, no, it's in foreclosure. It hasn't been foreclosed on. It is not an REO or owned by the bank yet. And the homeowner is still entitled to either do something with it, such as settle the debt, pay it off, do some sort of loss mitigation, or sell it via a short sale if they're underwater or just a quick sale if there's some equity. So can you just touch on what the terms are between?
So, yeah, I mean, look, a foreclosure is just a legal process for the bank to enforce their mortgage. You didn't pay your mortgage. The foreclosure is the process to now take the house, which, so when you're in foreclosure, you are in the legal process. They file a complaint, and they're now going towards the step of taking the house through the foreclosure process. Foreclose on just means, hey, we're in the process, and now the bank went ahead and sold it at the auction. Either the bank bought it back or a third party. That's being foreclosed on.
Yep.
So when you're in foreclosure, it's the legal process for the bank to enforce the mortgage and take back the house.
Yep.
That's all that is.
And so what is a Liz pendants and what does that mean when it's filed?
So
in terms of a mortgage foreclosure, because I know a Liz pendants can be for anything.
Well, yeah. So then Liz, it's the same thing. So a Liz pendant. So when the bank files their complaint, summons a complaint, they also file what's called the notice of pendency. All it is a document that gets filed with the Supreme Court and also recorded with the county clerk that says, hey, this property has some sort of litigation that's going. This property. There's a lawsuit regarding this property. In this case, it would be a foreclosure. And it could be for a variety of other things, but yeah, it's just a notice to the world. Hey, look, there's litigation regarding this property. That's all it is.
So from the time a Liz pendants is filed to the time, say, there's an auction on the property, how much time is there usually, and what are the steps to get there?
Oh my God! I mean, that's
I know
we could be here for 3
I know.
I mean, it could take.
People ask me this all the time. That's why I want to ask you.
I mean, it could take. I don't know. The best case scenario, a year and a half. Best case scenario. I mean, and I have cases that are going on for 11 years. I haven't been practicing for 11 years, but I've taken over cases that have already been litigated.
Yep.
So it really depends. I mean, the process, there's so many different variations in the process. I mean, in most general terms, you don't pay your mortgage, right? Within 120 days, the bank will then send a notice of default. Hey, 30 days, if you don't pay, we're going to commence an action, or we may commence an action.
Right.
They sometimes will also serve that with a 90-day notice, which is required under law, which also gives you a whole list of what your rights are. If you don't, so there's a 30-day, a 90-day. If you don't comply if you don't bring the mortgage current in that time frame, they're starting an action. You have time to file once they file their complaint. You have 30 days from your first settlement conference to respond to the complaint. After settlement conferences, then the bank brings their first motion. I mean, if the motion gets denied, it can go into what's called discovery proceedings. mini trials. If they eventually win that, then they go to judgment of foreclosure, which is their second motion. And eventually, if they win that, they go to auction. Now, in between all of that, if you lose, or if we win or they win, we could appeal.
Mm-hmm.
I mean, this process can go on forever. And
Forever and ever.
there's so many different ways it can go.
Yeah.
Well, not so
And
many,
if
but
somebody doesn't hire an attorney, usually the process is sped up because
Yes.
they go into default and then no one's fighting it. So there's nothing to delay it or to slow it down.
that is, yeah, that's correct. And I mean, look, it also depends on who the bank's firm is. Sometimes you get a very
And how with it or not with it they are. Yeah.
well, 100%. I mean, I've seen cases where the homeowners is nowhere to be found. They're in Florida.
Right.
They don't care. They thought they had to leave. They got out, left.
Yeah.
And it's taken them 5 years to foreclose.
Yep.
I mean, that's
And then I call them and say, hey, you still own this house. You want to do something with it? And they're like, well, I thought the bank owns it. And I say no. And I show them proof. And look, the litigation's still pending and we can do something here. So is it ever too late to start doing something?
no. I mean, it's never too late. I mean, I've had cases where there was an auction in 4 days and we got everything overturned, or we can, we work something out, like maybe a modification, short sale, whatever the case may be. It's never too late. Look, it's never too late, but there are situations where it's very late and they've done nothing.
Right.
Where it puts the attorney in a situation where we have very little to.
Right.
There's not much we can do.
Right.
Other than a miracle.
Not much of an argument to really make
The-
unless there's something that was overlooked that's
Correct.
big.
So I always tell, you have to get involved. Be proactive.
Right.
You're not paying your mortgage. You're served with a complaint, or even the notices, the pre-foreclosure notices. You have to hire an attorney. I know nobody likes us. We're expensive, but you're going to lose your most valuable asset most likely.
Yeah.
So that's you have to get involved. You have to be active right away.
Then how come people would go to a bankruptcy attorney before they would come to, say, a foreclosure defense attorney? Why do you think that is?
Well, I mean, this probably everyone has their own personal reasons. I mean, I've had clients, I've had that happen all the time, and I ask them, and they say, "Well, I didn't want to be personally liable for the debt." That's usually what the case is.
Right.
And sometimes they'll go online, they'll read something that doesn't really make sense.
Yeah.
Hey, if you file for bankruptcy, the bank can't take your house. That's absolutely not true.
No. Right.
Hey, if you file for bankruptcy, the mortgage goes away.
Yep.
No, that doesn't
Yep.
work like that. That's most scenarios I've seen.
From what I find is that the bank puts the mortgage into a charge-off department, which just means that they can no longer debt collect, but it doesn't take care of the debt. It doesn't pay it off until the house either goes up for auction or is actually sold, either via short sale or other means,
Yeah.
So-
and I've actually had a conversation with that with a couple mortgage brokers on what exactly in your back office is being charged off mean,
Right.
because you see that a lot. You'll get a letter
Right.
from, hey, we charge off the debt. They're still going to enforce it, but they have their own, I think, internal ways of how they write it off
Yep.
for whatever reason.
Right. But it still will show up on title. It doesn't mean that now you have a debt, the free and clear of a mortgage on your house.
Correct.
Speaking of free and clear mortgages, so there are some cases where people do hire a foreclosure defense attorney and think, I'm going to get my mortgage expunged. Can you just touch on how that may or may not happen?
Well, there's so many people that they're
I hear it all the time.
They're reading online. Oh, I get a free mortgage. I have it happen all the time, and that comes down to, I don't know who you spoke to, but attorneys, you have to set clients' expectations. You have to be real. What are the chances you're going to get a free house? Not likely. But there are a lot of cases out there that, for instance, the bank files an action. Once they file the action, in order to avoid what's called the violation of the statute of limitations, meaning the mortgage is no longer enforceable, they have to finish the action within 6 years to be safe.
Right.
There's some exceptions to that rule, but just for general terms, if you don't finish it in 6 years, you're opening yourself up to a mortgage that is in violation of the statute of limitations and it's no longer enforceable. Those are the cases that you'll see. They'll publish it in whatever, New York Times, whatever. And then the homeowner reads that and they say, well, this person got their house for free. Yeah, well, your circumstances are nothing like that. But essentially, I'll just give you an example. I took over a 2013 case, house in Freeport. The bank accidentally commenced the action against a dead person. It's now 2025. They commenced the action in 2013. I filed a motion to dismiss. You cannot sue a dead person.
Right.
It's way past 6 years from the day they started.
Right.
Now you have a mortgage that is unenforceable. So what's going to happen is they're going to restart the action. Well, assuming they restart the action, I'm going to just file a motion to dismiss based on the statute of limitations. 6 years expired,
Hmm.
or I can be proactive with the client and tell them, hey, look, if we want, we can file a quiet title proceeding, which essentially is asking for a court order saying that this mortgage is in violation of the statute of limitations, is no longer enforceable.
Right.
Did I answer the question?
Yeah. No,
I'm
it's
really
it.
sure.
Because it's, after a while, if they're just kind of leaving things open-ended and they're not taking care of it, at what point can they, come back and try to like make an argument and be like, oh, well, you know what? Actually, I want my house for free now, even though I didn't do anything with this for 7 years, 8 years, 9 years, but they might still try to use that argument of, well, the bank didn't have the rights to foreclose. And then people always try to talk about predatory lending. That should have, this and that, and the bank's a crook and all this. And it's like, well, did you sign the note? Yeah. Did you get a mortgage? Yeah.
Yeah.
Did you stop paying? Yeah. These are all things that like sometimes people are trying to use the argument, well, they'll never take my house and I have this and that. And, sometimes they'll hire an attorney to put these defenses in, and it's almost like beating a dead horse because they're never going to win. And they think that they're going to stay in their house forever sometimes. So can you also touch upon like cases like that where people think they're going to be able to stay and just cannot afford it or do not have the standing to, versus what their other options are to get out of it, rather than just letting the bank take the house?
Yeah. So, I mean, there's a lot of cases, I have a bunch of them, where they just simply didn't pay because they lost their job or whatever the reason is. But there's nothing in the court filings that allows, there's really nothing there that's going to, even if we have it dismissed, for standing or whatever the reason is, the bank, there are exceptions to the rule where the bank can just restart the action, and eventually there's just nothing in there that the bank, that we can do to stop it. It's almost inevitable that's going to happen. The reality is you didn't pay your mortgage. You do have defenses. If they don't apply in your case, and the bank complies with everything they're supposed to under New York and federal law, they're going to win eventually. The case I described before, it's a little bit of luck and a little bit of knowing what you're doing. But in the cases where we can't get the case thrown out and get that free house, I mean, there's several options. You have to, and you have to be real with the client. You have to tell them, you have to just be honest with them. I know so many attorneys that give the whole song and dance. You're getting a free house. We talked about this before, but you have to be honest with the client. Hey, look, eventually the bank's going to win. Save your money. What is your current income? Let's try to get a modification. If you don't care about losing your house, then maybe sell it via short sale, or if there's equity, sell it on the open market. The bank will give you some money to relocate. Every situation is different, and one of the first questions I always ask, what do you want? What is your outcome?
Right.
What is your best outcome?
And usually their answer is, I have no money. I can't afford to live anywhere else, and I'm going to stay here forever.
Yeah. No, you're right.
And in those cases,
you have to. I have them right now.
Yep.
And I have to be realistic with that. You just, first of all, you have a fiduciary duty to be real. You can't lie to the client.
Yeah.
You have to just be realistic. Hey, look, eventually we're going to run out of bullets. We might, maybe we do win down the road, but realistically, the way I see this case going, there's nothing here that's going to be able to overturn or prevent the foreclosure.
Right.
So you need to figure out financially what you want to do. I mean, it's a hard conversation to have.
Yeah.
Maybe you get some third-party investor coming in willing to give them some sort of funds. There's also limitations to that as well.
Yeah.
But you got to be realistic. We're going to lose at some point. You don't have the funds. You're living off Social Security. I'll keep you in as long as you can. But you have to have a game plan. You have to have a backup plan.
Yep.
Is your family willing to help? And it's an awful conversation to have.
I know.
But it happens. So.
And what about like with estates and reverse mortgages? Because I know that's a big brunt of our business, is people that either have lost somebody and they've inherited this house with debt, and they think that the debt is going to attach to them as the next of kin. Is that true?
No.
Right.
No. So, yeah. Right now, there's an influx of reverse mortgage foreclosures. I mean, it's incredible how many there are. The reality is, think about a world that if your mother or any one of our family members passed, now we have to pay their mortgage. Absolutely. I mean, that would be chaos. So that's one thing that homeowners I get that question all the time. Well, I don't want to be liable for the debt. Well, you're not. But you're getting notices from the bank because you have the opportunity to save the house. Most people don't, because when they take out a reverse mortgage, by the time it gets to the foreclosure process, the debt way exceeds the value of the home.
Right.
But the homeowner, the heirs, assuming there's no will and they don't deed the property to somebody else, next in kin automatically own the property under New York law, and they have the right to try to save the home. There's certain options depending if it's Fannie, Freddie, HUD, whatever the case may be.
FHA.
FHA.
And if they don't want to save it because the house is, in original condition from the 60s and they're like, they've moved on with their life, they don't live there, then their option is to sell it via short sale. The bank might give them an incentive.
Yep.
And get the debt paid off. And then none of that will attach to the heirs, correct?
That is correct. Yeah. The debt. Yeah. Again, just think about a world where you would have to pay off your family's debt, especially the mortgage.
That would be chaos.
Would be a mess.
So in New York right now, given the way that like everything is going with courts and the judges and this and that, and how many cases there are, what do you see is going to happen over the next, 5-10 years in terms of foreclosure filings?
I mean, look, 10 years, I don't know. But look, if it's anything has how it's been in the last 5 years, assuming there's no pandemic, I mean, I get calls every week. I get probably 2 cases a week. And if the numbers, I've seen the numbers, you get, depending on which what market analysis you're looking at. I mean, in the second quarter of this year has spiked dramatically in some counties versus last year.
Right.
So you can listen to whatever you want. Oh, the economy's getting great, this, that, and the next thing. It's great for people with a lot of money. Most people in foreclosure don't have money, and the foreclosures are rising dramatically.
Yeah.
Believe it or not, Suffolk County, if you look at the stats, has dropped. That's one of the only counties that has dropped. Nassau County's increased. Nassau County, Westchester, Queens actually went down. Brooklyn, which is Kings, Staten Island, and the Bronx has seen a recent increase over the last year. I think 73%, which is outrageous.
Wow.
Which is it's insane. And this is all public record. So if anybody wanted to look up foreclosures per day, you can actually look it up per day and see how many in each county are being filed.
There's about 10 or 15 per day in each county.
That's ludicrous. And this is not, hey, these are new foreclosures. A lot of investors that I've dealt with, they talk about lis pendences. You can look up a property and you'll see multiple lis pendences because they expire every 3 years.
Right.
So it may look like, oh, this is a new foreclosure. It's actually
refiling.
Not. The bank refiled it and it's showing up in the public record. The stats I was just they're not exact numbers, but they're rough estimates. That's new foreclosures.
Yeah.
That's homes that were never in foreclosure.
Right.
Which is patently insane.
Yeah. And it's also because I guess over the last few years with the, price gouging and everybody overbidding on all these houses, they're realizing just like what happened in 2005, 20 years ago, they were overpaying for all these houses. And then they realized, well, I'm not going to pay for a house that's, $600,000 when it's only worth $5,000. And they just decide to stop paying or whatever. And then the houses went back to the bank. And then I think in that time period too, there were just so many foreclosures that they couldn't go through them all, right? And that's why there was such a big flux back then.
Oh, well, yeah. So are you referring to the market crash?
Yeah, because I feel like we're still going through cases from back then too.
100%. I mean,
20 years now almost.
I mean, I have a case right now in Brooklyn that's from 2009.
Yeah.
That's right in the heart of the financial crisis. And when that happened, I mean, you also had a lot of other things that went along with that. You had a lot of fraud that kind of prevented some of these foreclosures. You had one famous law firm that was handling not a majority, but a large portion of these foreclosures that went out of business. They now go to other firms. You had another firm, Rosicki, that had a lot.
That got.
I don't know the percentage, but it was a massive amount of foreclosures that they were handling. They went out of business.
Right.
Now they give them to somebody else, and now they got to take in those
Restart
cases.
it over.
It's just not only are they slow moving, but the courts are slow moving.
Right.
Thousands of foreclosures per day. I mean, or per month, whatever the number is. It causes massive delay, and you see it's just very. If you're in it every day like I am, you just see it.
Yep.
It's just.
We're going to be in this for a very long time.
What Nassau County just did is Nassau County used to have one judge handling thousands of foreclosures, which makes no sense. What are you thinking? Who came up with that? I don't know who came up with that. But now you have I think there's about 10 judges now spread out handling all the foreclosures.
Right.
And they're still slow.
Right. 'Cause there's only so many things they could do a day and motions. And then if there's defects in it and they have to, fix it, send it back, reject it,
I mean, if I file a motion, it might not be heard for 2 to 3 years, which is wild.
Right.
And it's almost expected at this point.
Right.
If you have a client that wants to just, hey, I had no money, I can't do anything, you file a motion, they'll sit there for 2 years without the judge making a decision. And if you lose that motion,
Right.
you can appeal that. So you can really make a mess of the process. It's already a mess in of itself. But if you're a good defense attorney, you can cause havoc.
Right. So now what's the difference between if it's an estate versus if it's the actual owner's house? Is the process any different? Are there extra layers to it? And whether it's a reverse mortgage or not, but just the owner died, then what changes?
Okay, so I'll try to make so you're asking questions that require a lot of
Yep.
specific, detailed responses.
And it depends on the situation.
And every situation is different, but I'll try to make it as clear as possible. I die, and the bank cannot sue me because I'm dead.
Mm-hmm.
I'm on the mortgage, I own the house. I die. There's two things. What they should do is they have to go through due diligence. They have to find the heirs.
Right.
And have to commence it directly against the heirs.
Mm-hmm.
Or if there was an executor or administrator appointed, they can sue them directly.
Right.
Bring the foreclosure that way. A lot of them don't do that.
Mm-hmm.
A lot of them will just file an action against unknown heirs of this estate, which is, the court's a little iffy on it. But if someone dies, they can commence it against the heirs directly. They have to waive their right to seek a deficiency judgment. That's clear in the law.
Right.
If you're going to go after the heirs not personally, if you're going to sue them directly,
Mm-hmm.
waive deficiency, and you can do the process that way. If the homeowner's alive and he dies during the process,
Mm-hmm.
now, what they should do is go to the surrogates court and have an administrator appointed.
Right. Like the public administrator.
A lot of them will just appoint the public administrator just to speed up the process. They're not going to wait for one of the heirs to decide one day.
Right.
Hey,
Especially
I'm
if
gonna
there's no
become the
equity,
administrator.
they're not going to.
Most heirs won't do it anyway because number one, they don't even know they have the right to do it. They
Right.
don't even know they own the property, a lot of them.
Mm-hmm.
So if the homeowner dies during the process, yes, the fast way for the bank to do it is to go get a public administrator appointed and then and then sue the public administrator directly and go that way.
Mm-hmm.
A lot of time they don't do that.
Yep.
A lot of time they just, it's funny. I'm not going to I could be here for 4 hours talking about how many times they just mess up the process.
Mm-hmm.
But it's like very clear. The law is very clear on what they should do and they still don't do it.
Right.
So homeowner dies prior, sue the heirs directly, waive deficiency. If he dies during the action, sue the public administrator directly.
Mm-hmm.
And there's some variations along the way of what you can and can't do, but those are the two main situations.
And then once they do die, say somebody dies without a will because there was nothing in the estate, what rights do the heirs have to the property and what can they do?
Well, all right, if there's no will, the heirs automatically become the owners of the property under
All of them.
the estate powers and trust law.
Mm-hmm.
Automatically become the heirs. If there's 5 of them, they divide it, 1/5, whatever it is. And then they have a right to defend the foreclosure. There's certain rights that the New York courts are very clear that they don't have and that they can't raise. Most defense attorneys raise them anyway. But there are certain defenses that the homeowner, the original homeowner had that the heirs do have.
Mm-hmm.
So yeah, I mean, they can just defend the action as if they were the homeowner for the most part. But again, there are certain defenses, very strong defenses that the homeowner could have raised that the heirs can.
Right. Now, what happens if the heirs decide, or say one of them wants to do something and the other one's like, I don't care? Is there anything that can be done if one of them wants to either buy the house back or sell it or do something to save it? Like, what are their options if, say, they don't have cooperation from the other siblings or whatever, or, they can't find them? What can that one person do?
Well, I mean, the easiest way is just to go to the surrogates court and become the administrator of the estate. That's it. Because once you're the administrator, you have the right to sell the properties, and you'll deal. Sometimes the surrogate court will put restrictions on when you can and can't sell. But once you're the administrator, now you control the estate.
Right.
If you sell the property and there are proceeds, you have to make sure they all get their share.
Mm-hmm.
But if there is none, you want to do a short sale, you have the right to do a short sale or whatever
Right.
the case may be. But the quickest, easiest way, become the administrator.
Right.
Control the estate.
Mm-hmm. And they have the rights to do that even if the house is in foreclosure and even if there's more
100%.
money owed on it than what it's worth. And none of that will tie to them personally, correct?
Correct.
Okay.
Correct.
Um,
But well, the mortgage debt won't.
right. The mortgage debt.
Yeah.
Unless they have their own debts, which is, there's nothing we can do about that. So let's talk about surrogates court now a little bit, since that's our other end of things that we deal with a lot. We know Supreme Court with the foreclosures has its own, deficiencies. What about surrogates court? What are things that can delay something from going through or speed things up? Like what can help or hurt a process of probate being done?
Well, I mean, so probate. What I found is, number one, it's just an antiquated court system. I mean, you look like you're in the 1500s. The way that it just looks old. They operate
You walk up
very
to the
slow.
computer, you type in
Oh
a
my
couple
God,
things, and
it's kind of funny actually. But
yeah,
I mean, to speed it up, look, you want to file your surrogate petition, whether it's administration proceeding or probate. You want it done in one shot, meaning you have all the correct heirs, you have all the proper death certificates. You need certified death certificates. The original will. You want to make sure all of that's in line before you file. Once you file, it's kind of in the hands of the court.
right.
Because
And which clerk looks at it? And
so
what they
yeah,
want.
exactly. Now each county operates different too. I mean, Nassau County, for instance, just has. I mean, first, most of them aren't attorneys looking over your documents.
Right.
And if there's questions about that, then they have to go up to the higher ups. And then sometimes I'm arguing with the attorney. You're asking me to do something that I don't even need to. It's not required by law. You don't deal with that in the Supreme Court.
Right.
But
So surrogate court is a little bit like you're dealing with less people that know a little bit less about the situation.
the vibe that I get is that they get a checklist.
Yep.
Hey, has this been done? I mean, if you spell the name wrong or you doesn't come up right, if there's one letter missing, they'll reject the whole petition. Like my name's Dominic, Dominick. If I leave out the K, they'll reject it.
Right.
Your name's incorrect. Who cares?
Yeah.
Who cares? Like,
Yeah.
why is that rejected? And now because it's rejected, you're causing 2 months of delay.
Right. Because everything takes a couple
Has that
months.
happened? No, what I just told you, but that's an example of what I'm talking
Right.
about.
Right. Little
So-
things are off or something's missing and has to be restarted all over again or refiled.
And that's very basic. So your question was basically,
What can help or hurt surrogate court
so
in the
you
process?
so surrogate process is just, you got to be everything's very tedious. You got to cross your dot your I's, cross your T's, and just you got to stay on top of them as well. So once my petition's filed, I'll follow up with them every couple weeks. Do you need anything from me? What can we get to push this along? And
Yeah.
look, I get it that they're swamped. They are. They're as swamped as the Supreme Court. And I don't think they have. I could be wrong. The resources that the Supreme Court does have, but you just got to be very specific and cross your T's, dot your I's. Like, you just got to be
Submit the paperwork properly the
it's
first
got to
time.
be submitted properly. But what you do notice is just an example, they'll reject the petition. You make the correction, you send it back, and then they reject it again, saying, "Oh well, I don't know why you did this." Then you have to show them the email that you were asked to make this correction.
And then they keep telling you different things. I know we had that happen a few times.
So I mean, as far as making it faster, you just got to stay on top of them and make sure everything is perfect, which it never is. And
But I feel like they've been a little bit better lately. Like I know we just had one that we just put in like a month ago, and we're already getting letters on it.
yeah. So I mean, look, if there's no heirs or there's one other heir and they file a consent, like they're not going to object to your petition.
Right.
The court will push that through.
So what are some delays that could be caused in surrogates court if, like, say we don't have everybody's cooperation on the estate, all the other heirs?
Okay. Yeah. So one, just an example. I have one petition. We just got letters on it. There's about 6 or 7 heirs. 3 of them, half of them are out of state, half of them are in state. If they're in state, you have to personally serve them. If you can't personally serve them, that becomes a massive delay, because then we go back into court. The court says, well, you didn't personally serve them. You don't have jurisdiction at that point. So what you have to do is now file a motion with the surrogates court asking to serve these people by alternative service. Your process server has to provide you with due diligence, an affidavit of due diligence to show you, hey, look, we did this search. We went to the property 4 times. We couldn't find them. But based on our search, we think they're at this property,
Mm-hmm.
and the court has to accept that. That motion, you file it, you do it everything right. It could take a couple months before they even decide it. Then you have to go serve them at the new address. Like that's just one thing. That's a common problem that you'll see is you have 8 heirs, 6 heirs, whatever it is, and you can't personally serve all of them. That's a big problem.
Mm-hmm.
Because a lot of them are avoiding service
Right.
because they think that they're being sued. They don't understand the process.
Right.
So
They don't want to be involved, and which is why they didn't cooperate in the beginning to begin with. So
usually, yeah.
yeah, so they don't want to sign a waiver, which allows, they don't want to put their name on anything because they're just afraid that it's going to tie to them some way, somehow.
And when you're dealing with heirs, they're always, like you said before, their first inclination is, "Oh, I'm being served. I don't want anything to do with this
Yeah.
debt.
Yeah.
If my name's on this now, do I have to owe the debt?" That's probably what, for the most part, I
Yep.
think it is. But
Yeah. They don't want to be held liable for anything, and they feel that if they get involved, it's going to like somehow come back to them. But it's actually the opposite. When you get rid of the house and you sell it and you pay everything off, and then it's over. And no one's going to come after you.
yeah.
So that's what the purpose is of like doing a short sale or a short pay, right? Is to get everything taken care of, and then the bank will issue the letter of undertaking, which what does that exactly mean?
So a letter. A letter of undertaking is just a letter from the bank telling the title company, once this closes, we're going to discontinue the foreclosure. That's all that is. That's a little different from, I think, what we're talking about.
Paying off the debt and everything. But that will actually say we're going to end foreclosure proceedings. This is done once this is paid off. So
Correct.
sometimes people think if they stick their head in the sand, it's all just going to go away.
Yeah.
But if you actually take proactive measures to go out and either get appointed administrator or sell the house or do something to at least alleviate the debt off the property, it'll take care of a lot of this stuff. So, and get you out of the situation rather than prolonging it another 10, 15 years or whenever the courts get it together.
Yeah. And look, the reality is if the heirs didn't do anything, what's going to happen? Not
Right.
much. It's just,
Nothing either way. It's just,
yeah.
at least they could get it over with sooner and possibly get some money out of it rather than wait for it to one day get foreclosed on.
And in the meantime, they're probably getting millions of, solicitations served sent to them. Hey, work with me, do this, blah, blah, hire this attorney.
And in some other cases like we've had recently, they're getting violations from the town. The town is calling them saying, oh, you're the, next of kin of this property and the grass is 3 feet high, or there's people breaking in, and they call the next of kin because they're like, you're listed here. So, we're going to go after you. And then they get afraid and, they don't want to deal with it
happen
anymore.
A bunch of times. But, 100%.
And also we could bring up squatters in this instance because how many cases we have right now with squatters in them, and a lot of them are estates, and the people have just broken in and decided to just live there because in New York, once you break into a house and you're in there for 30 days, you now are considered a tenant. And, the police aren't just going to come kick you out. You have to still go through landlord-tenant court, even though the squatter removal process is a little bit quicker than a landlord-tenant removal on an eviction. But people are still able to maintain residence in a house. And if nobody's stopping them and the house is in foreclosure and the bank doesn't own the house yet and it's still in the owner's name or in the estate's name.
And they're living for free.
Exactly.
Essentially living for free, yeah.
Yeah.
And I think eventually that law is going to change. I mean, they already started taking steps to kind of changing that. If you notice what happened in Queens County where the woman, I think it was a multi-million-dollar house they went in. Usually when big money's involved like that,
Right.
New York legislature starts to react, which
Mhm.
is a shame, but it is what it is. But I do think eventually that law, I'm hoping it does change because people, it happens all the time.
Yeah.
It happens all the time. People living for free and they destroy the house a lot of the time.
Yeah.
So,
Or they'll renovate it and rent it out, or make a burner phone and start collecting rent for however many months. And
that's another thing.
Yeah.
You'll see a squatter. Oh, they create a fake lease.
Mhm.
So I mean that's just. And I'm sure if you Google right now how to be a squatter, there's a laundry list and a
Yeah.
guide on how to do it.
Mm-hmm. There was a guy making videos telling everybody how to do it. So,
So-
so now, what is one thing that every person in New York that's in foreclosure right now should know or should maybe be wary of, that if they're not going to take action, what would happen to them versus if they hired an attorney and tried to be proactive about it?
I mean, you're gonna lose your house. It's just that simple. If you do nothing, if you do absolutely nothing, you're making the situation worse for yourself. if you know, if they file a complaint, you sit back and you hide whatever it is you want. You don't want to get involved. It's making the process much faster and easier for the bank.
Mm-hmm.
I don't care how bad the law firms can be, the bank's law firms, they're bad, but it's going to make the whole process quicker. And you don't know what your options are. You have to hire an attorney. I mean,
Right.
I think it's just that simple.
Mm-hmm.
Or at least try to speak to one. Or go to your first settlement conference, because there you can at least speak to free counsel. They'll at least kind of guide you in the right direction.
Right.
Most people don't even do that.
Right.
I can't tell you how many cases I get where judgment of foreclosure is already granted, and they didn't do a damn thing through the whole process. And then I ask them, I have to explain to the court why you didn't do anything for 3 years.
Right.
You can't say, I didn't know what to do.
Right.
I didn't have money for an attorney.
Right.
They're not going to accept that. So the less proactive you are, the worse situation you're putting yourself.
Right.
So I'm sure you can at least find an attorney out there. You don't want to go at it alone. There's plenty of us out there.
Mm-hmm.
You just got to be proactive. It's that simple. Stop reading. Stop going on Google and Googling how to stop foreclosures, because half the time I get clients sending me documents or a law that's in Illinois or Florida.
Oh yeah.
Like, this is not, or even in New York. I'm like, yeah, but it says that, but it doesn't mean that, because judges interpret it totally different.
Right.
But anyway, get an attorney, be proactive. It's just that simple.
Mm-hmm.
There's no other way to do it.
And if somebody wants to keep their house and wants to keep it, but can't, maybe has some money, but maybe can't afford it completely, what would you say to them about trying to pay an attorney to do a modification for them? Do you think that would be a waste of their time?
Pay an attorney to do a modification.
Would it be a waste of somebody's time to pay an attorney to do a modification for them if they don't have the money to pay back the mortgage, meaning their income will just not support paying back this mortgage, but they're paying somebody to get them a modification?
So, I mean, like that's like a tough question, because
I see that happen all the time.
And that's a lot of the time I use that as my argument in court. Hey, look, they hired this attorney. They were under the impression they were being represented not only in this getting a loan mod,
right,
but in the foreclosure. But look, if they can get a loan modification, sure, it's worth it. But a lot of the time, if they don't have the money, they can't.
Right.
But there are some new programs, and every case is different. Every mortgage is different. I have a case right now where we just got, it's called a streamline modification.
Mm-hmm.
They didn't even ask for the client's finances, and
right,
the client agreed to do it. They're gonna pay it just to get out of foreclosure and figure things out after.
Mm-hmm.
So every case is different.
Mm-hmm.
Would I say, if I had to tell, if some client came to me and asked me that question, I would say, are they defending you in the foreclosure? And if not, what is that going to cost for them to do that as well?
Right.
Not just doing the modification.
Right.
Because as I said before, if they're doing a modification and you end up going to settlement conferences, that doesn't mean you're not in default.
Right.
If you go to the court settlement conferences with the modification and you still, even though you're participating in the proceeding, but you don't respond to the complaint, you're still in default.
Because I see that a lot too, where someone's like, oh, I have an attorney helping me. And then I look on the case detail page on eCourts and there's no attorney listed on the defendant's side.
Yep.
And I'm like, are you sure that they're representing you? Because it doesn't say anybody here and nobody's filing any answers. Oh, but they submitted things to the bank and this and that. And it's like, yes, they're probably going through the servicer to put in some sort of loss mitigation application, but they're not actually, like you said, doing anything to stop or slow down the foreclosure process.
Yeah.
And
I one specific example, one instance I had, we basically threw the attorney under the bus. We said he didn't do his job. I didn't want to put the retainer in.
Mm-hmm.
And I'm not sure I could have got the retainer. I don't think they handed it over. But in my motion, I lost.
Mm-hmm.
And the clerk kind of indicated, hey, look, if you actually had the copy of his retainer,
Right.
You
Use it as
probably would have
proof.
won.
Mm-hmm.
I did that on another similar case because I have a ton of cases. We actually got the retainer. We found the provision saying, yes, we're doing the modification, but we're also going to help you defend the foreclosure. They didn't do that. We won. I mean, you don't want to we redact it, but you don't want to normally do that. But
Yeah.
look, they're putting the client in a very bad position to lose again their most valuable asset, most likely.
Right. And I just see it happen so much, where there's attorneys charging people to process modifications or retainers. They're paying them hundreds of dollars, sometimes thousands. and it goes nowhere, and the person ends up just back in the same position that they were in, before, or even worse, because nobody did anything for months and months. So if there is anybody out there that is looking for an attorney to help them with foreclosure defense, what would you suggest that they either ask the attorney or show them or make sure that they do, rather than just, because sometimes people are like, I have an attorney representing me. They throw their hands up in the air and they're like, they think that they're absolved from any responsibility, that the attorney's just handling everything. But as we know, attorneys handle, sometimes hundreds of cases at a time. They can't be on top of every single thing all the time.
Yeah.
So what would you suggest for a homeowner to do that is working with an attorney, and how to protect themselves and make sure things are going according to?
Well, look, you have to you have to stay on top, like anything else. Stay on top of your attorney. Make sure he's doing the right thing. Hey, give me an update. Where are we at? I get it all the time. The way I set it up is I have a calendar. Even if there's nothing going on in the case, I'll shoot an email quick to the client. Just give you a quick update. Here's what's going on.
Yeah.
You got to stay on top of your attorney, just like anything else.
Yeah.
I mean, a lot of attorneys that you think they're actually protecting you and know what they're doing don't. I mean,
They have too much going on, or not enough knowledge on it, or
yeah. I mean,
Yeah.
it's very common, believe it or not. I mean, it really
Yeah.
is.
And it's the difference between somebody being able to win their case or not, someone losing their house or not. And it's a really big, important asset, like you said before. So got to make sure you're working with the right person. So if people want to reach you or schedule a consultation with you, what's the best way to contact you?
Email or my phone number. So,
What is your office phone number?
so my office is 516-820-0712. And my email, it's kind of long. It's DC, my first and last initials, at CalligaryLawPC.com. That's DC at CalligaryLawPC.com. It's very long, but that's what it is. So that would be the best way to. I would say, if you can't get me by phone, email me, and I'll get back to you.
I must say you're one of the most responsive attorneys I've ever worked with, so that's good.
Yeah, you have to be.
And you're in communication with the clients even before I am most of the time, which is great.
Let me tell you this: you have to stay in constant communication to keep that relationship. You just have to, and it's a part of your job. And your client has to know what's going on.
Yeah.
I mean, it's an ethical obligation, number one, but you have to keep their trust, and you have to make sure they know what's going on as well. I mean, it's very simple. But
Well, thank you. And if anybody has any questions about their case or about hiring Dom, either on the seller side or for probate stuff or any other real estate matters, you can reach out to him.
Sure.
Thank you.
Thanks.